Today we're going to be talking about the recent decision of F&M in the High Court, coercive control as a form of domestic abuse, and the applicability and use of Scotch schedules going forward, hopefully how that's been impacted, how that might change, and what we can do about it. So let's start off with the case itself. I appeared for father in this case in relation to two young children. Now, the initial application went as far back as 2017. Father's the applicant, but mother's the complainant in the main fact-finding hearing. I should have linked to the judgment in the chat already. You should be able to find it there. I'm not expecting you to read it all now. Like many family cases, it's a heavy read, but it's worthwhile when you've got the time to digest that entire judgment in full when you get the opportunity. But in summary, the case is quite unique in that the allegation of coercive control was localized to a reasonably short time period, although the intensity of that coercive control was significant throughout the relationship. Parties met at university as first-year undergraduates, and mother was pregnant with the first child very early on. That culminated in the parties ultimately leaving university. Mother alleged that this was because of father's insistence. Father later left as a result of being unable to finish his course. That relationship from the start was characterized, it said, by father's controlling behavior in mother's day-to-day life. And there was also, interestingly, significant police involvement throughout. This was because the maternal family, who was separated from mother due to not living in the local area of the university, repeatedly contacted the police to investigate on her welfare. Father also engaged with the police when the reverse happened, when mother would return home for short periods in her parents' care. One of the reasons that this case is also very interesting is that police involvement was fairly laissez-faire throughout the relationship, despite the level of intervention. This seems to have been built on the fact that there was an adopted presumption that there was some sort of risk of honor-based violence towards mother and child, which was a false assumption built upon assumptions that surrounded mother's ethnicity. Throughout the 3-year period of the relationship, the family, mother, father, and the first child, were moving around continually. The various number of moves ranged from 13 to 15, and it's alleged that father was limiting mother's autonomy throughout the entire home, locking her in the property, demeaning her and controlling her financially. There's also allegations of intensive and long-running sexual abuse. That's not something I'm necessarily going to cover today, but there were findings made in respect of those in any event. Mother left father in 2017 after 3 years of being in that relationship, whereupon the second child, father's child, was born after she had left, and proceedings commenced thereafter with an application from father. But the other important element about this case is another thing that is unusual in these types of proceedings, because after the relationship ended in 2017, father became involved with a third party, Miss D, herself with 2 older children, herself a separated parent. By all accounts, Mr. and Mrs. D, now separated, were having a largely amiable management of their child arrangements. There were no orders in place. And it was subsequently alleged that father relocated Mrs. D and the children by force to a Welsh local authority, which prompted an application from the maternal grandparents and from Mr. D in respect of that relocation. There followed a set of proceedings in Wales, where the maternal grandparents and Mr. D applied for originally contact and eventually return of the children. And there was extensive social work involvement during that time. From the social work information that was available, it was alleged that father had exerted more coercive control over Miss D in a surprisingly similar pattern to that shown in the main case. The inclusion of the local authority evidence from Wales was the subject of another appeal, another reported case, R&P. The link should be in the chat, but I can resend those afterwards, whereupon the Court of Appeal concluded that this evidence was relevant as similar fact evidence to show propensity for coercive and controlling behaviour in this case. Its inclusion wasn't opposed at fact-finding. The fact-finding hearing took place for 2 weeks in November, and nearly all of the findings alleged were found. What's important is that Mr. Justice Hayden, who was hearing that case, didn't slavishly glue his findings to the schedule of allegations that was provided and filed in this case. At the end of his judgment, Mr. Justice Hayden was invited by counsel for mother to make the following comments. I've highlighted those. I don't propose to read them out, but what you can see is that he remained generally quite neutral, accepting that there were limitations on Scott schedules, and that in circumstances of coercive controlling behavior, it, and I quote, may not easily be captured by the more formulaic discipline of a Scott schedule, unquote. This was the starting suggestion. And in practice, as I'll go into later, Mr. Justice Hayden didn't need to grapple with the Scott schedule in the same way many of you will be familiar in your normal fact-finding hearings. He didn't go as far as to criticize their inclusion or say that they had no purpose. He told us a huge amount, though, in his main judgment about the utility and usefulness of the Scott schedule in this case. We had a number of advantages. The first was that the narrative of this particular case is restricted to a 3-year period. A 3-year period which was characterized almost entirely, it is said, by coercive controlling behavior, and you'll see Mr. Justice Hayden's findings in respect of that. That allowed him to focus his analysis in an entire context. In so many cases of coercive control, the fact pattern doesn't add up so conveniently. We don't have a short, relatively short, intensive period. We have a series of disconnected individual incidents over a longer period of time, which may not show a pattern so much as they are incidents that happened. Because in F&M, the coercive control was limited to such a period, it gave Mr. Justice Hayden the opportunity to look at the whole history from cradle to grave. He went through the entire history of the case, as you'll see from the judgment, through that lens. 2 other points, though. Firstly, it took us 3 years to get to a fact-finding hearing, which meant the accumulation of evidence was enormous. Mother produced at least 4 statements, albeit father didn't respond to all of them due to changes in representation throughout. We also had extensive police evidence, text messages and conversations, and WhatsApps. There was a lot of evidence localized in that period in this case, let alone the second unique point, which was the similar fact evidence. Now, we had plenty of evidence in respect to the second case, but remember that it was not Mother's case that she needed to prove what had been happening in the second incident, the B plot, as I refer to it with Miss D. All she needed to establish was that there was a propensity for the coercive controlling behavior, of which there was still significant evidence when we were supported by the local authority documents from the Welsh Social Services. The final thing that's important to remember here, and why Mr. Justice Hayden didn't feel the need to be belaboured with the Scott schedule, was that he didn't take a binary approach. Many of you will have encountered cases where the judge's or magistrate's approach is purely found or not found. Those are the only 2 options. Occasionally, you may come across judges who listen to both sides of the story and find somewhere in between or elements on both parts. Mr. Justice Hayden, by advantage, as I said, of the temporal nature of this case, was able to look at all 3 years and examine the whole history. He didn't stick to the schedule and simply say found, not found. To do so would have been in disservice to the entire narrative of the case, and also limit the scope in which we were examining coercive and controlling behavior. There was a great deal of discussion in the closing submissions about definitions for coercive control, which I'll get onto later. But what this is significant about is that this case by its nature didn't really have to rely on a Scott schedule. It didn't need to be approached as a slavish exercise in ticking boxes and identifying whether each individual element was proven or not proven, because everything had to be taken in the context of the entire relationship. Incidents of coercive control were pleaded, but Mr. Justice Hayden examined the case as a transaction in one 3-year period. A matter of days after F&M judgment was released, the Court of Appeal heard a joined appeal covering a number of similar issues, and I'm not proposing to examine that in full. Firstly, because Scott schedules were not the whole focus of that case, and it is largely around the machinery of practice direction 12J and the other elements that come with domestic abuse, although Scott schedules form and coercive controlling behavior form part of that. We're still waiting on that judgment, and I would say this: if there's going to be any significant shift in how we approach litigating coercive control in private child disputes, it's got to come from the Court of Appeal. For now, Mr. Justice Hayden's provided us with the prologue, just the warm-up act. Those appeals are going to have significant impact on how we approach domestic abuse for the future. And if you'd like to find out a little bit more about what's going on there, there's a great write-up on the Transparency Project's website in their blog of the various components and the individual appeals that formed up the Court of Appeal case. But for now, we're just waiting. So what is coercive control? And as I said before, we spent a lot of time in closing submissions establishing where the boundaries and what we could point to for definitions. It's the nature of us as lawyers to look at the convenient definitions that help us tick boxes, tests we can apply and tests we can't apply. It's fair to say the amount of examination we had to complete was a struggle. And here is just an idea of what we were looking at in terms of material, which Mr. Justice Ray Hayden refers to throughout the judgment. Both sides in particular wanted to focus on the criminal legislation as well as our well-known Practice Direction 12J and the family procedure rules. I'll also point out at this stage, the current domestic abuse bill does include coercive control in the definition of a domestic abuse, but itself contains no definition of coercive control. The last document, the Assessing Risk of Harm to Children and Parents in Private Law Children Cases, also provides an interesting study in an examination of the treatment of coercive control in private children matters, though I am sure it's formed part of the Court of Appeal case as well. So looking at the materials, we start off closer to home with Practice Direction 12J from the Family Procedure Rules. You might notice that there's actually two distinct definitions of coercive behavior and controlling behavior, whereas we are often pleading coercive controlling behavior. The criminal legislation addresses coercive control as a single element. We really can use these two together, and I don't regard these definitions as wrong nor mutually exclusive, though there's probably a side case that pleading them separately unnecessarily complicates the issues. These simple definitions in 12J gives a good flavor of what's going on, though you'll notice, and I'll come back to this, that both the Practice Direction 12J definitions cover single acts as well, which in the tone and how we generally plead coercive control strikes one as quite unusual since they're supposed to represent patterns of behavior. If I have to draw a distinction between the two, I'd say coercive behavior refers to the personal impact and emotional impact on the complainant, the evocation of fear from a threat of harm, punish, frightening, whilst controlling behavior extends to use of resources, opportunities, domicility and subservience on the part of the complainant. As I said, it's probably academic to try to draw a distinction between the two of them. They can both be present from the same impetus from the respondent. They can both be responded to in equal measure equally by the complainant. Our criminal cousins, on the other hand, as ever, provide us with a much more comprehensive, or complex, I should say, definition. And this is part of the Section 76 definition of coercive control. You'll notice a few things that are already familiar to us in that legislation. The personal connection element, many of us have seen that from Family Law Act applications. And that's also been adopted as part of the domestic abuse bill in any event. That is putting, so to speak, the domestic and domestic abuse as the intention. What's really important here is what we often don't have but do, so to speak, in family proceedings. And that's what criminal lawyers know as the mens rea, the mental component, the knowledge component. Coercive control is a negative implementation of knowledge. That is to say, you know how the complainant will respond to an impetus, and then you abuse that impetus to generate a negative response from the complainant. Now, I submitted to Mr. Justice Hayden that someone can't coercively control someone without knowledge, or at the very least, say the court reaching the conclusion they ought to have known what the impact is, and that forms part of the criminal legislation. The next part is there needs to be a consequence, and that's easily measurable, the negative impact on the complainant from the behavior. Criminal law breaks this down a little bit differently by saying it's fear of violence or alarm or distress, which has a substantial adverse effect on one's usual day-to-day activities. There isn't a consideration in anything we've looked at so far about delayed impact potentially potentially post-traumatic stress disorder scenarios, but those are easily conceivable within both the meanings we have. There's not presumption that the emotional impact should be immediate in respect of coercive control. The next element is the transactional personality. There have to be patterns of behavior for coercive control, not a single incident. As I said earlier, I'm unclear why Practice Direction 12J feels that a single incident would do. I read it as there would still need to be an incident that may be harmless to instill the knowledge component. You need to know that what you're doing is going to have that effect, and there may have to be some precursor that instills you with that knowledge, or at least the basis of the court's expectation you would have the knowledge. I've laid out at the end the defense in the criminal proceedings, not for the most part for our purposes, but just for completeness sake. And you'll notice again that's focused on the mental component. According to this defense, if you act in the complainant's interest and in reasonable circumstances, but not in situations which involve assault or the immediate application of violence, rather it's only the alarm or distress situation, you have a complete defense to the allegation of coercive control. Honestly, I can't see many situations that's going to arise or be pleaded in a family context when it comes to domestic abuse. I'm not sure how often it's relied upon in a criminal context. Part of the definition that I offered to Ms. Justice Hayden that was actually refused was the need for us to be aware that coercive controlling behavior itself is not recognizably negative. That knowledge component and that subversive personality established by it needs to form part of the court's analysis. In many relationships, an ordinary behavior would not strike anyone as being coercive and controlling. But in this specific instance of the relationship we would be discussing in the proceedings, something elevates that. The judge didn't accept a narrow definition of that, but accepted there has to be an analysis performed where the behavior is looked at through the lens and in context. So what did we learn? What are the challenges when pursuing allegations of coercive control? We have no consistent definition. We have consistent themes across the definitions. And there should still be a continuous transaction and series of behaviors, though there's some elasticity about the time frames that could be deployed in. The fact is, coercive controlling behavior, while recognizable in context, cannot be helpfully boiled down in the way that physical, even financial abuse or sexual abuse can be boiled down. They're assisted by the fact they fit into a moral universe that people can look at objectively. Our man on the socially distanced clapping omnibus can identify when a rape is a rape, or identify when there's a rape allegation, possibly more to say. But it's not as easy to identify on recognition what coercive control is, or if it's relevant or applicable in the context of this relationship. Now, when we talk about transactions, we're talking about a series of behaviors. And I should say, there doesn't seem to be any way to distinguish a qualitative or qualitative analysis. Are more occasions worse? Are there more serious and less serious instances of coercive control and behavior? It's not easy to make a definitive answer to that. What we do have to consider is that these behaviors work on a cumulative basis. They get worse either over a series of transactions or intensity in a shorter period of transactions. And finally, context. As I mentioned before, not all behaviors are inherently coercive controlling, but they have to be read in the context of the relationship. If a somewhat or observably benign behavior has the impact of dependency or limitation of resource or alarm distress, that informs the behavior and thereby encourages analysis of it as coercive control in the context of the relationship. That is why context is everything. One point which I want to deal with very briefly is how Mr. Justice Hayden addressed the idea that we all need to become more educated and the assistance of professionals would help us more. This came about, as I mentioned before, because in F&M, although there was a lot of police involvement, very little to no action was taken by the police, who had concluded that there was a risk of honor-based violence towards mother from the maternal family. You'll see Mr. Justice Hayden debunks that by describing it as having not a skin killer evidence to it. And That really demonstrates the need for us to be aware of how coercive control can operate in relationships going forward, for us as both family practitioners and professionals who work in childcare generally. But then, of course, there's the real question. What does this mean for Scott schedules? All of those elements, all of those challenges, they cause Mr. Justice Hayden to suggest that Scott schedule lacks the nuance and the capability to look at a case of coercive control. You only need to look at the judgment. Now, imagine if that judgment was a fraction of the length, where we had been limited to 5 independent, unconnected allegations without the scope to consider the entire transactional history. You've probably all seen that before, where you have a case of coercive control, you're pleading it, and you hit a brick wall when a tribunal suggests to you that a limited roster of allegations at 5 or 6 is the best way for the court to allot its time. Summing up in 5 allegations is the tool of the Scott schedule. And it's very important as we move on that Mr. Justice Hayden paid little attention to it in F and M. Now, I know most of you know what a Scott schedule is, but for anyone coming from the outside of family law practice, it is an A4 landscape table with a series of columns for allegation, response, evidence relied upon, and then finally a box recording the judge's finding. It should probably ring some alarm bells, and I discovered recently that the original Scott schedules were designed for the apportionment of chattels. They were forced into being used in the way we use them today. Due to this wonderful visuality and layout, the Scott schedule looks like an easy document to pick up and understand a series of allegations, the question and answer response, and how the case is to be litigated. In practice, with the 5-6 allegation limit we're often restricted to, they do anything but, especially in cases of coercive control. I'm sure many of you who practice in this field are able to come up with some good numbers, but thus far in the pre-practice direction 12J period, I have seen as many as 17 individual allegations pleaded in the Scott schedule. And I heard last week of somebody being expected to pare down a list of 58. It'd be interesting to know if anybody's got higher than 58. That's possibly the most I have heard of in recent times. The idea from restricting them is mostly for court time, as far as I can understand it. I highly doubt if even a 5-day fact finding would be enough to deal with 58 potential allegations. I'll be happy to be proven wrong on that. Occasionally, there are other limitations. One of the most common ones is temporal. You can't make an allegation of domestic violence of a certain age. That is elastic in case to case. And in others, there is sometimes some menial attempt to create a hierarchy. So if the child was present, obviously in instances where the child was the complainant themselves, those almost always find their way into schedules. Any restriction on the Scott schedule in a case of coercive control that limits the available examples being pleaded is disadvantageous. The idea then is that the Scott schedule is used as a Bible, that you can, as I said, pick it up, look at the complainant's case, look at the respondent's case, and then understand how the case is to run when it appears in evidence at a fact-finding hearing. They're usually supported by statements which vary from flowing prose that builds on the allegation itself, or simply restating the facts of the allegation. At fact-finding hearings, courts treat Scott schedules like shopping lists, and finding out what's proven or not proven if the evidence doesn't match up perfectly, or just using it as a guideline, sometimes finding anywhere of shades of grey between the two stories of the parties. So even in its use and application, the Scott schedule is inconsistent, though in its form, it largely stays the same, or at least it's supposed to. That's not to say we shouldn't be using them at all and they're utterly useless. Where they are good is where we need shopping lists, where you have single, isolated moments in time which can conveniently be dealt with one by one. When a court deploys a Scott schedule at a fact-finding hearing, it's saying it doesn't matter if you go to the shops and you can't find the butter because we can still buy the eggs. The presumption, just like a shopping list, is that the allegations are non-cumulative. You can deal with them individually. And that is how Scott schedules are designed, or appear to be designed, to work. And when the incidents have no relationship to each other, aside from the parties involved, when there's some temporal distance, when they can be considered evidentially on their own merits as a single incident, the Scott schedule operates reasonably well. The question I would have is, how often is that? No one can make their minds up about whether Scott schedules should be brief, depending on the allegations, or whether they themselves act as statements. I've seen cases where Scott schedules are being submitted without statements and the statement to be filed later on. Most of the time, they come in together. They also work best when the moral personality of the act is clear, that is to say, physical, sexual abuse, where people don't need a redefinition of what the actual offence being claimed or the harm being claimed is. We all know what the conditions for an allegation of rape or any other form of physical violence. We don't have that to our advantage, as I mentioned before, in allegations of coercive control, because they are subjective. Of course, coercive controlling behavior is wrong in its own sense, but it's also subjective in its own context. A rape is not subjective all the time in its own context of the relationship. A rape doesn't become a rape or stop being a rape because it's in a different relationship. It's still struck to its own series of rules. So in those situations, Scott schedules can be used and do work. But when they don't work is when it comes to elements such as coercive control or transactional patterns of behavior. Coercive control is an evolution of domestic abuse. We're not going to have every case which just has physical violence or allegations of rape now. We're going to have the slow burn of the emotional, psychological harm that coercive control can inhibit upon the complainant. Because the Scott schedule takes the shopping list approach, it can't manage these transactions. It can't manage patterns of behavior. Were you to stay within the lines of a Scott schedule in a coercive controlling behavior case, your 5 allegations are 5 individual incidents that are immediately divided by nature of being named individually and then examined by the court in many situations individually. The problem with Scott schedules in these cases is that approach, is their very own layout. A Scott schedule can't prove a trend. It's almost consequentialist. You can't use a Scott schedule in this way with 5 allegations one by one on a shopping list. You can't use a Scott schedule to establish a pattern of behavior unless you already get your findings. So for example, were you to have 5 allegations of coercive control on 5 instances, and you were able to obtain findings in all 5 of them, then the court would reach a conclusion there was a pattern of behavior. But the Scott schedule in that form doesn't let you plead a pattern of behavior in its own right without the finding first. That's cart before the horse. And then you come to the next problem. If you have to plead coercive control in that way, how do you establish the pattern anyway? You start asking questions like, how many do I need to prove to show a pattern? Are you pleading the 5 separate incidents on their own merits? Do they cumulatively impact each other? If incident 1 is related to incident 2, then the shopping list approach can't apply. You need your butter and your eggs to make these sufficient findings. The binary approach, similarly, it did happen or it didn't exactly as you pleaded it. That doesn't take into account the impact of on complainants. Even if there's insufficient evidence to establish it, the court doesn't have the capacity to tell someone how they feel or don't feel after an incident. Now, even if it was coercive controlling or not by nature, that emotional impact could inform another allegation of coercive control by any vulnerability that's caused from the first incident pleaded. Again, because Scott schedules are not cumulative in personality, they lack the ability to work with patterns and trends. So that gives us a few options. And as I emphasized before, F&M didn't get rid of Scott schedules, and I'm not entirely sure the Court of Appeal joined appeals will get rid of Scott schedules. But what are we going to do about it? What now? It would be too easy just to chuck them out of the window. For better or worse, in many cases I mentioned before, your convenient table of allegations and response has its uses. How would anybody be able to respond to a case that was pleaded amorphously, vaguely, or extensively if every single incident was relevant? We wouldn't have the court time to hear cases, numerous cases like that. we'd end up having fact-finding hearings that were just holding one statement against the other with no way to focus the court's attention on the issues. And remember, whilst we do that, say, in children proceedings at final welfare stage, the fact-finding hearing is a specific creature designed to use the schedule, the Scott schedule and the schedule of the allegations to determine those incidents and establish risk factors arising from domestic abuse or other behaviours. It's a unique creature in that sense. So we can't just have a statement each and fight one another with the content of every single comment that's made and with argument and counter-argument throughout every single point. If the purpose of fact-finding hearings has evolved to focus on domestic abuse and to identify threats and risks to children, it needs to have some sort of way to demarcate and identify the factual elements. We've got three options. Obviously, throwing out Scott schedules out of the window completely is probably not feasible. There's been a suggestion of the so-called findings document, and the last, which is the one I know most of you will be familiar with, is one I term as the umbrella schedule. As I said before, Scott schedules do have applicability, and the case for throwing them out of the window altogether is probably not sustainable. Single incident cases, by far the most applicable for Scott schedules. Imagine you started with an application for an ex parte for a change in residence or a prohibitive steps order, which had a lightning rod incident. You'll see this a lot also in Family Law Act applications. Those are uncomplicated, if only on the number of incidents that you're pleading. Arguably so simple you could deal with it in a statement alone, but let's say you could have 5 or 6 incidents relied upon from an initial Family Law Act statement, or that supported your application ex parte for a change of residence and child arrangements order or a prohibitive steps order. They might be unrelated to each other, but in so beyond there is a loose pattern, but the need to demonstrate a pattern isn't vital to your case. You know that in order to obtain your prohibitive steps order, you need to prove the single incident, the sole incident accordingly. And let's say the case is simply limited to evidence between the parties. You might have some police evidence, but you don't have extensive third-party evidence. And then the parties' accounts could be completely distinct from one another, so the court could approach it as a binary decision. Oh, and also the incidents could be unrelated, so it's possible to deal with them all individually. And then those could be based entirely on allegations of sexual abuse or rape. And all of a sudden, you have a case which is perfect for a Scott schedule. But that's the problem. We need to stop being forced to think that cases are appropriate to fit into Scott schedules and think about how we use Scott schedules to work for us. Because if we are forever being forced to fit our cases into the rubric of a Scott schedule, then we will inevitably conclude that Scott schedules are not sufficient for purpose. The answer, instead of getting rid of them completely, must be developing approaches that we can use to get our cases inside of them. In fact, I can't think that there are a majority or a large number of cases that fit Scott schedules perfectly. More so in a world now where domestic abuse can be transactional and awareness of transactional domestic abuse, not just coercive and controlling behavior, but repeated actions. As those become more important, as those become more aspects of the domestic abuse cases that we are pleading, the more that we need to be focusing on how we can get Scott schedules to work for us. One of the first developments and proposals for that is what we call, what's been referred to as the findings document. This is for those of us who don't practice in public children law, this is similar to what is called the local authority threshold that must be met for either interim or final orders and care proceedings. It's been mooted as an alternative as much as a year back, and it uses that model to give an overall finding and then itemize the components that build towards the finding. This was mentioned, as I understand it, in the Court of Appeal, joint Court of Appeal cases. And it's generally expected now that that one takeaway is how to assess in the Scott schedule how the impact of these incidents affects children. We often have it at this time that there is this assumption, it's not an assumption, but it's baked into the Scott schedule that any allegation of domestic abuse is harmful for a child, whether present or not. that gets conflated in some situations where some courts will restrict the available allegations on the basis the child needs to be present or directly affected. I would argue that's for Kafkas to determine, frankly. It's hard to say how much control over a schedule can be achieved pre the fact-finding itself, beyond looking at indicators such as impact and whether it's domestic abuse. The long-term impact on the child and welfare, that's a matter for Kafkas. Now, the findings document is not a bad idea, and there's some technicalities. Of course, there's no threshold in private law children proceedings. The analysis that the guardian performs in public law children proceedings is conducted by a Kafkas officer who has no direct involvement with the fact-finding until the judgment is provided to them. But the idea of it is still appealing. It was responded to in practice, I think, over the last few years by innovations that we now use ourselves. Because surely, the wordsmiths we are, rebranding a Scott schedule and giving it a new name isn't the answer. And as I said before, the answer has to be, how do we get a Scott schedule to work in our favor for the case we're pleading or opposing? And the answer became the umbrella schedule. Now, you have all most likely seen one of these. A few of you I know in attendance today have actually used them and have been in cases that involve them. And the trick is how you draft the schedule and what you're actually looking to achieve. When the court says there should be 5 to 6 limitations, we approach it thematically. So a larger umbrella heading: coercive control, physical violence, sexual violence, financial control, anything that needs a pattern of behavior established like coercive control, financial control. You put an umbrella as one allegation. Then you generate a series of subheadings beneath it that identify individual incidents. This methodology gets round the 5 allegation limit. It focuses the court's mind, like the findings document, on the overall picture with itemized incidents, and gives the court, as the Scott schedule should, a rubric and model to work with. Now, there's some dispute about whether that's just plain cheating, loopholing, or clever drafting, but it is a viable approach to Scott schedules and fact findings, which I have seen deployed to great effect and was deployed in FNM, although in FNM, the need for Mr. Justice Hayden to focus on the schedule in that manner wasn't relevant nor needed. It does have one severe problem, and it's a cumulative problem. Say you have one heading and 5 allegations you pleaded individually underneath your thematic heading. What's the threshold for getting your umbrella heading? Do you need to prove 3 or 4? Do you need to prove 5? One doesn't prove a trend, let's say, for argument's sake, so it doesn't need to be at least 2. And then do they have qualitative or quantitative distinctions? Is one of your subheaded allegations more serious? Can it be determined as more serious? Is its context as seriousness dependent on the other components that come before or after it? That is your difficulty, because a court won't want to simply make a finding on the umbrella schedule if you get nowhere on your sub-allegations, which of course will have evidential basis supporting them and will be balanced by the court. It's a real problem in coercive control cases because there's no qualitative distinction all the time, but also a trend doesn't change the intensity of the emotional response from the complainant. One incident could be strong enough to implicit a series of emotional responses that affect all others. You could prove all of them on a smaller level. You could prove one which was a key incident in the overall mental functioning for the complainant and the impact of that, or you could prove not that one and all the others. It's difficult to find margins by using an umbrella schedule. I should add as well that the umbrella schedule has the advantage also of being able to be deployed in a hybrid sense. You can use a coercive controlling allegation alongside single incident allegations, which the Scott schedule was meant to be used for, which is advantageous. And this is the approach I feel we need to adopt at the moment when faced with coercive control. It was the approach used in FNM, but as I said, not relevant because the case didn't need that, but not all of our cases are as convenient. If temporal restrictions remove elements of your case over a 20-year relationship, how easy is it to establish coercive control? And that is the answer we need from the courts. Can you deal with the cumulative problem, and how are we supposed to manipulate Scotch schedules to our favour to plead these cases and respond to them in the best possible way? This is a make weight. It would be assisted greatly by some official judicial support for them and recognition. But for now, they work and they be used to great effect. I should add that the umbrella schedule approach, in the same way it can include single allegations for isolated incidents as the Scotch schedule was intended, it also helps in non-coercive control. One good example I've been told about is an allegation of repeated drug use and a pattern of drug use throughout the relationship. It's still, again, a trend, a pattern that needs to be identified to the advantage of the court and for the evidence to be heard. And the same structure was used in those particular cases. But I'm afraid until the Court of Appeal gives us a bit more guidance, we'll still be going on. There's clearly a desire from judges to keep cases running, even if we're using umbrella schedules. And not every case is going to fit in the same way as F&M did on its factual nexus. But the overriding thinking I would encourage from all of you when you identify coercive control in your cases is to remember that we need to make the Scotch schedules work for us, not to force things into Scotch schedules where they don't fit. I'd say the 5 allegation limit needs to be reconsidered, but that's difficult because it is a time pressure that causes that rather than some other reason. Temporal, welfare, other restrictions on it could be re-examined. But ultimately, the 5 allegation limit needs to be more flexible from case to case, and I am aware that sometimes it is. The idea is that if a Scotch schedule can be made to work for us, it's easier to litigate with because it's digestible and it's usable, but we have to find a way to make them usable. But what can you do right now before the Court of Appeal possibly sends word on high? One of the recommendations I see a lot is the early identification of domestic abuse issues in private child cases. I would encourage that. The idea is that we're supposed to be making decisions about fact findings at first hearing dispute resolution appointments. More often than not, I see cases adjourned to have another hearing to decide on a fact find once we have a schedule. The C1A, which is theoretically by its appearance designed to be a sort of proto Scotch schedule before you get one in the main proceedings, is not fit for purpose and is generally filled with whatever comes to mind on the application. If we started treating them as Scotch schedules and had something to hand at the first hearing dispute resolution appointment, we could case manage these cases earlier. How many times have we done cases where our C1As don't look anything like the Scotch schedules? Or in reverse, we see a C1A and then we receive a Scotch schedule down the line full of allegations that absolutely nobody had ever had in their contemplation, or worse still, when they're raised in a Kafka safeguarding letter you didn't get on the day of the FEDRA and you received either when you got there or immediately afterwards, or having to go into court with no knowledge of the safeguarding recommendations. That is what we need to be doing. If complainants need to raise allegations of coercive control as early as they are able, I appreciate sometimes these allegations don't formulate and they germinate over time. Or for the benefit of respondents, we need to know what we're going to have to answer and whether we're going to a fact-finding earlier. COVID hasn't helped things as fact-finders have been pushed farther and farther down the line. But the earlier we can manage that, the easier it's going to be to get these cases heard and fairly and understand what is the situation when we come to that fact-finding hearing. Using statements for context, I feel I see this enough to a degree, but would like to see it more. My preference would be to see shorter schedules and statements more detailed. In coercive control, it's vital to understand the backdrop of the relationship and why the pleaded incident demonstrates an incident of coercive control. You can't fit that into a schedule. That's the schedule's fault. If you can't make the schedule work for you, work around the back with the statement and use the statement to provide the context. Because as I said, F&M, context is baked into the facts of the case. We don't have the advantage in the vast majority of cases. Get your context, your background, the situation in which you're asking the court to analyze it into your statements in support of schedules. And if you can, try not to submit schedules on their own because they ultimately serve no purpose without that context, particularly in cases of coercive control. So this is the part where I'm happy to field any questions that anybody might have from the chat. So got one from Nadia. First of all, I've just seen in the chat, how do these work with time estimates, especially with magistrates? The problem is, Nadia, I wish there was an easy answer to that question, because we all know the difficulties the magistrates have in time scales. One option is to, when it comes to looking at the fact finding, again, strict case management, witness templates. I'm not seeing enough witness templates as far as I am concerned. And then escalating, sorry, Nadia, help me, escalating what up? With the number of allegations, or bringing the issues? Are you asking whether when you'd escalate it to a DJ? For the timescales therein? Okay. Yes, I'd agree with some. That's all right. Nadia got very passionate and decided to use caps for a moment there. It's definitely going to assist that we have some guidance, hopefully from the Court of Appeal, or possibly from the President. Depends. The President is hearing the Court of Appeal case as well. We need to know about the ranges on coercive control and where they fit in. Now, I think one of the problems, and I think you'll agree with me, Nadia, is that coercive control has been labeled as a type of cause of action, a type of complaint that magistrates are able to analyze. But the problem is, as you've seen when reading F&M, they're more nuanced than that. It can be more nuanced than that. It can be more complex. And it's not as easy to just say, well, it doesn't seem that complicated. We need to have a look at how we apportion these cases. Appropriate training, greater education was something that Mr. Justice Hayden dealt with in F&M. So I would agree with any sort of support or guidance we could have about how we approach these cases going forward. Do feel free, if there's any other questions you'd like to just bring up in the chat, I'm more than happy to help out. I think if I wanted to sum it up in a very brief sort of way, it's really that point I made at the end about we need to stop fighting Scotch judges, even though in many cases they inherently are our enemies. And we need to figure out more ways to have them work to our advantage and be able to use them in ways that we can approach our cases. And that's in the interest of both. Remember, for an F&M, I was for the respondent father, I wasn't for the mother, so I wasn't the one pursuing or putting the case, we were responding to it. The easier it is via well-drafted documents to put a case, makes it easy to respond to and allows the fact finder to go more swimmingly and clearer. One thing I would add as well, there are two, I suppose, just as an extra points to this for fact findings generally. Firstly, be very aware of that point I made before about binaries. I'll come back to that question in a sec, Camilla. And about binary, about judges proving and not proving allegations. And secondly, if you are for respondents, be very aware that for some reason there's a pattern, there is a pattern of judges often raising concern about not responding or bare denial. I struggle to sort of understand the element of bare denial in these cases, because if your case is that it didn't happen, your case is that it didn't happen, but be aware of that. Camilla, your question is, what is your view as to contact for children with a perpetrator of coercive control? I'm afraid I am not the person who's qualified to express a view about that, because it depends on case to case. It's a matter for CAFCAS to assess risk factors once there's been findings of coercive control, and they make recommendations and to assist the court. So I can't say about my own personal views about coercive control and impacts on contact, because that depends in every situation from case to case. Shirley, I've sent all of the links I've referred to throughout this talk for everybody's benefit. I forewarn, just in case, when the meeting closes, the actual links are likely to disappear. So I'd recommend if you can copy paste, or alternatively, I think Rukai might be able to email the links around to everybody. But you'll see there, I've linked our YouTube channel, which contains other webinar content we've been creating, plus this talk will be uploaded to there. The actual judgment of FNM, which I recommend everybody has a detailed read of when you've got the time to. It's quite a hefty judgment. And also 3 blog posts from the Transparency Project's summary of what's going on, what happened in the Court of Appeal case, as far as we know what's going on. And finally, the Assessing Risk of Harm to Children and Parents Prime Private Law Children cases, which is a study in the impacts throughout. Thank you, Rukai. Rukai will email all of those links around to you for those of you who haven't been able to get them. Any other questions that anybody would like to raise? From Sharon. In your view, is there now more scope to ask the court to consider additional allegations arising at a fact finding which are not included in the schedule but which come up in evidence? Sharon, there's your problem, and this is the issue. The idea, I think, is that fact findings really ought to be front loaded. You've got to come in with your schedule knowing what your case is. I appreciate that's not ideal, that it is not easy to know your case at that stage if other information comes out in statements. I think it's a dangerous proposition. The first problem you've got, and I'm assuming you're querying findings that are fact finding as they come out in evidence. So in fairness, nobody's going to be prepared for that to some degree. I would say I've had mixed experiences, that sometimes lesser findings, dependent cumulative findings, come up in evidence that need to be examined, and the court is willing to do that. On other occasions, you will find that you will press a court to really find an allegation because it becomes a point of confusion and conflict between the parties of the fact-finding hearing. But in practice, a court won't. This is your binary, not binary, guideline or not problem. I would try if it becomes evident from your hearing and the evidence. And if you can't, then the court is going to do what it needs to do. There might be scope for appeals if they're cumulative, but that's the difficulty you find. They're all expecting us to front load schedules at the moment, and that's the approach we need to start with. Simon's asked, do you encourage clients who've been coercively controlled to complain to the police? And what experience do your clients customarily have regarding police involvement? Thank you, Simon. Yes is the answer to your first question. Where possible, if coercive control is becoming a significant theme, I'd always advise them to. Of course, you have the inevitable problem that the police are elastic or inconsistent in their own responses, although I have had cases which have removed the need of making findings for coercive control in the fact-finding and children proceedings, because criminal proceedings have taken over and made those findings. Generally, I think many of us have that in many aspects of domestic abuse, mixed. In answer to your second question, Simon, what are clients' customer experiences? I should add both sides as well. Alleged perpetrators of coercive control have been treated poorly on occasion and better on others where they've been listened to. This may be the case in all circumstances of domestic abuse. I would not go as far to say that I feel coercive control is treated with less seriousness, although I have seen examples of situations where clients have been advised to go and seek police support and not had the level of support as they would do in, say, sexual violence or general physical violence. But it is one of those things that, just like any other form of domestic abuse, police involvement is designed to help, can help, does help, and on occasion doesn't change the situation. And I take Camilla's point as well, that sometimes, just like any, I should add, just like any domestic abuse, occasionally it's very difficult for complainants to actually be able to make any report to the police for whatever reason, whether overborne due to the coercive control, not able to escape the situation. To use FNM as an example, none of the police involvement, as far as I can recall, in FNM was actually imposed by mother. It was either coming from the maternal family or from father. And I take Camilla's point very, very valuably that while you can advise people to seek help for coercive control, it may not be easy, just like any other type of domestic abuse. And that's very telling if you look at FNM and how police involvement, for the most part, was never instilled by mother until she managed to remove herself from the relationship. any more questions that anyone would like to raise on anything in particular? Right, well, I think then we will, Rakari, I think we'll wrap it up there.
That sounds good.
I'm happy to send through, Rakari will email you all the links I've been referring to throughout. They're all worth good reads in and of their own right. And at some point, I'm sure there will be further discussions to be had after the Court of Appeal case comes through. But I'd like to thank you all for attending. If you do want to watch this, the rest of this again, you can access it via the Coram YouTube channel. But thank you very much, everybody, and have a fantastic rest of your day.